Okay, thank you, Sakada, for your introductions, and good morning, everybody. I'm very pleased today to make a presentation on the professionalism in legal practice. And the presentation is prepared a lot based on my personal experience as a practicing lawyer. I started practicing laws in 2006. So it's more than 10 years of experience in the legal practice. And before I become a practicing lawyer, I was a Secretary General of the Bar Association, where I got a lot of involvement in training Cambodian lawyers and also in setting up the Royal Academy for Judicial Profession for training Cambodian judge, lawyer, and other court officer. And currently, in addition to my legal practice, I'm also advisor of the Ministry of Justice and also member of the Council of Jurists of the Consular Minister of Royal Government of Cambodia as well. So, a lot of discussion in the presentation, you will see that I hope it will be useful for all of you, but if you have any questions, just feel free to raise your questions. I hope that the webinar will be as much interactive as possible rather than me talking alone to the screens. And some of your names are not very familiar with me, and maybe if you could share your face so that I can remember in future, I can see or I remember you're participating in my seminar, okay? So as part of introduction, HBS law was set up established in 2005 as a register with the Bar Association of Kingdom of Cambodia. HBS law is a full service law firm that assists clients both in contentious and non-contentious matter. We have both local and foreign clients and advisor. Currently, we are a team of 70 plus people in our firm. Our mission is to create an environment in which our staff, which we consider as our greatest asset, are happy to work and ensure that our clients receive the best possible legal service and continue to the development, contribute to the development of the legal system and especially the rule of law in Cambodia. That's why professionalism allows us to achieve the first two main aims, and it's the basis for the third aim that we want to achieve. This is our, the mission of our law firm, HBS. And I skip this slide as Sakada have already introduced myself. So now we come to our topic today.
I think you haven't shared the slides presentation. You haven't shared the screen.
Huh?
I think the participants are not seeing the presentation.
The presentation, right? Okay. Okay. You can see now, right?
Yes, I think we all can see it now. Yes.
Okay, good. Yeah. So I just move on. I skip the speaker slide. Sakada already introduced me. So now we come to our topic is why do we need to be professional? So being a lawyer is not a job. As I say, it's a profession, and people judge the legal profession by action of lawyer. We must do our best to uphold the prestige of our profession by complying with our professional rule and ethics. It is a profession that is regulated by law, and there's a certain standard that we need to follow and to comply in order to maintain the professionalism, to uphold the honors and the prestige of the legal profession in the country. The same as the medical doctors or judge They are also part of the profession. They are not we are not just doing job. We need to be professional when dealing with clients to ensure that they receive the best possible service. And we need to be professional when dealing with colleagues to ensure that good colleagues do not leave the firm for the wrong reasons. So, I mean, in many circumstances, whether you are dealing with the general public in the society, or you are dealing with your own client, or dealing with your colleagues at the law firm, you need to maintain certain standard of professionalism. That's very important. And when it come up to discuss the element of professionalism, I just try to list a number of points here, such as you need to understand the role, professional role lawyer plays. You need to understand the requirements, comply with rules regarding professional conduct, and other soft skills, which, I mean, these are a few items that I think are critical and important for lawyers. And I mean, some of you as a law student would need to understand that as well, because not only the technical skill that are important, but soft skill you can use whether you become practicing lawyers, or you will become a judge, or you will become government official, or doing whatever when you are involved in interpersonal relationship with other people. Your soft skill will help you a lot. So, but I mean, there are many other things that we cannot cover in this short presentation webinar. But this is just try to highlight some of the key points, key elements, which I believe are relevant and important for you to know. So I divided the presentation into two main parts. One, I will talk about the professional conduct, and another part I will talk about soft skill. So come back to understanding the role, professional role of lawyer in society. Or you will see that lawyer perform various representational and non-representational role. I mean, representational means you represent your client in the either negotiation or in the litigation process. But non-representational roles in a society, there are also other things that the lawyer also get involved. Okay. First thing that I can mention is lawyer act as an advisor. So when lawyer advise client, lawyer provide a client with an informed understanding of the client rights and obligations and practical implication thereof, and also like help client to prepare legal document or agreement for client. So when the client come to see a lawyer, they want to understand what are their rights and obligations when they want to enforce contract, for example, when they need to make payment, whether the other party fail or breach contracts or not, what are the remedy under contracts that. So as a lawyer, you will advise the rights and obligation of client in that regard. A lawyer acts as an advocate. Advocates mean you represent as a defense lawyer, or you represent client in a court proceeding. A lawyer asserts the client position in court proceedings. So when you go to court, you defend, either you are acting as defense lawyer or a representative of your client as a kind of representative as plaintiff. Then what you need to do is you try to assert position of your client, explain to the judge what is right and what is wrong, and what your client want to claim. Make a relevant argument to support the position of your client. Lawyer can also be a negotiator outside the court proceeding. As a negotiator, lawyer will seek result advantageous to client, but it must be consistent with requirement honesty. why I emphasize the requirement on honest dealing. It's important because, I mean, I will talk later on in the soft skill way and some of the ethical principle. Of course, you want to take as much advantage as possible for your client, but you need to commit to honest dealing. You don't cheat the other party because of your capacity as a lawyer. Maybe you know some tricks that are useful to take advantage of your client. But you would understand that when you take undue advantage over the other party, then sometimes the other party may cancel or terminate contracts because of the taking excessive benefits over the other party. And the lawyer have to maintain that also that principle. Lawyer can also act as an evaluator. I mean, lawyer act by examining the client legal affair and providing report to them. It's in situation where there's no dispute, there's not in the contentious matter. Maybe the client just want to assess whether they are in a situation where their business is in compliance with law and regulation or not. Or sometimes the client may just ask you to examine or conduct a due diligence on their business and find out, maybe give them a report on your assessment of its compliance. Other than that, I mean, the lawyer is also a public citizen. A lawyer should seek improvement of law, access to legal system, administration of justice, and the quality of service rendered by the legal profession. They should further understanding the public understanding and confidence in the rule of law and justice system. They should be pursued not only for the direct benefit of Cambodian citizens, but also for the benefit of foreign investors, which have indirect benefit for Cambodia. So these are part of contribution to society, other than, as I said, other than represent your client in court proceeding or working on their business or contracts, resolving their dispute outside the court system. But you also need to contribute as a public citizen, as a good citizen, contribute to the improvement of law and the rule of law, etc., justice system. And as a learned officer of the legal system, a lawyer should cultivate knowledge of law beyond its use for client. Employ that knowledge in reform of law and work to strengthen legal education. That's why some lawyer, they like myself, I'm not only practicing law at our law firm, but also doing some teaching. Yeah, so just to share my knowledge, I'm teaching conflict resolution for the senior government official at the Royal School of Administration. And so I have both senior government official and the junior government official who study at the Royal School of Administration as well. So it's a part of like, you learn the law and you try to share the knowledge of law to as many people as possible. This is a kind of professional role that the lawyer could involve in many ways. Okay. In terms of professional conduct for lawyer, so the first thing that is very important and come in my mind is a lawyer must be competent and diligent in representing client. So when I'm talking about representational role, the lawyer must be competent. So what does it mean, competent and diligence? First, we look at the legal knowledge and skill. So as a lawyer, we expect that, okay, at least you have a certain knowledge level of substantive law and procedural law. I mean, you study law at university, you spend like 4-year undergraduate students, and after that, you pass the bar exam, You got a training at the bar exam and also internship before you become a full-fledged lawyer. So the general public, especially your client, expect that you have the good knowledge of law. But in addition to that, as a good knowledge of law, as I said, the substantive law and procedural law, a good lawyer also need to have some other skill, like you have a good legal research. You don't have law in hand every time, but when you need to respond to a particular questions, you know where to find all the resources, the answer to your client. Then it's important to have a good knowledge of legal research. And not only research, you need to have a good knowledge of legal analysis, how to apply a certain article or provision of law to a particular case or particular matter. So not only understand the law, but know how the law would apply. I mean, in some country, they have a published precedent where you need to do a lot of research on understand how the court make decision on a particular case, and that could be applied to your client case. So this is more than just reading the code and the text. And other skill the lawyer need to have is like to prepare statement, to prepare a complaint. These are very technical skill. You need, when you are asked by a client to file a lawsuit, where should you start? How to draft a complaint, how to prepare a statement of defense. That are kind of skill that you need to improve and to build. So a good lawyer, at least they know that they have both technical skill and they know how to find the answer. When as a human being, you cannot remember everything or you cannot know everything. But when there's a particular issue, you know where to find it, how to search for it. Now there's a lot of like technology, Google search, and many ways that you can find information by searching online, and just pick up all the relevant information and prepare, respond to your client. So legal knowledge and skill are important. And then you need to be seraph and prepare. You know, not only just know the law and understand how to apply the law. In some case, you need to be well prepared when you go to court. The lawyer, I mean, the client will see, oh, how messy you are, how you organize your file, how you prepare your document, how you place your evidence, how you structure your idea, and when you defend your client, whether your document are messy or not. If you want to pick up something, you want to talk something, you want to show something to the judge, whether the file are in order or are not in order. The preparation is very important for lawyers to look professional in the proceeding, as well as in any other circumstances. You need to be very well prepared and focus on working on your client matter. Other thing is maintaining competence. Of course, when you graduate from the university and from the lawyer training center, you're kind of confident that you have a lot of a big pool of knowledge, of legal knowledge and skill. But of course, I mean, the law develop, the law update, new law come in all the time. And the change in practice in the court proceeding as well. Maybe the Supreme Court make new interpretation of certain provision of the law in the code. So you need to keep learning. I mean, learning, improving your competence. Both, as I said, both technical skill and soft skill you need to improve all the time. That's why working as a lawyer, always keep learning like student. You never stop learning. Improving competence. You need to be diligent, prompt, commit, and dedication. You need to commit to the client work. I mean, sometimes, most of the time, client need your response very urgently. Sometimes the client have to conduct a meeting in their board. Sometimes the client need to submit a certain document. Sometimes the client need to meet a certain deadlines, and they ask for the draft from the client, from the lawyers. So if I mean, some lawyer, the more you are famous, the more busy you are, and then of course the workload will kill you to some extent. But regardless of workload you have to be committed and dedicated to client work. I mean, so you must not have an attitude where, okay, because just deadline and I miss one day deadline and I just say sorry to the lawyer, I mean to my client. If you just keep that kind of attitude, then you will never meet the deadline. You are not committed to work overnight just to complete the transaction as planned. I mean, personally, sometimes I involve in the multi-party transactions where the deadlines are very tough. They need to close the deal tonight, where the conference call, where you need to have a call, you need to submit document to lawyer in London, where they are like 6-7 hours different from us. There are some one law firm in Beijing and one law firm in London, and 2 law firms in Cambodia have to call and have to conduct a meeting. If you don't have a spirit of commitment and dedication, then it's already midnight, then how to go to bed. So lawyer have to be diligent, and I mean I will talk more about that in the soft skill. But it's a kind of the lawyer, the client will judge you whether you are competent, whether you are diligent, whether you are professional or not, based on this kind of criteria. So a lawyer must act according to the scope and objective of engagement. Client will also judge you based on this representation, the objective that they want. So in principle, lawyers shall abide by a client decision concerning objective of the representation. In practice, sometimes the lawyer and their client are not very clear about the scope of their engagement. The client just expects that, okay, I engage this lawyer and this lawyer will do everything for me. And the lawyer believes that, okay, I am engaged for 1, 2, 3, and I am paid just my fee. I charge only for 1, 2, 3. I will not do this 4, 5, 6 items that are not covered in my engagement. So you have to be clear with your client at what stage of procedure that you are engaged for, what you need to do. That's why it comes to the objective of representation, what the client want to achieve. Before you confirm the engagement with client, you need to make clear about that objective. Otherwise, you will be in a kind of inconvenient situation or in some time a kind of dispute, and relationship with client will just be destroyed because of the misunderstanding of the objective. When the client set clear objective of your engagement, then you have to follow the objective. The lawyer must consult with client with respect to the means by which the client objective can be achieved. So keep informing client, keep consulting with client, so that you don't have any misunderstanding of the means you use. I mean, there's a situation where lawyer believe that, okay, because they engage me, they pay me, they entrust the work to me, I will decide whatever I want to do by myself. And then sometimes it turns out to be the objective of client are not achieved. Then you will get into trouble either to explain the client again because you made decision without consulting with client. So communicating and consulting with client consistently is very important to avoid any misunderstanding of what you do. And sometimes, of course, there's disagreement between the client and the lawyer in terms of how you use, what means you use to achieve the client objective. In that situation, some clients say, because I mean, I rely on my lawyer, I rely on your skill and knowledge and skill, so you make decision for me. But there are also situations where the lawyer, the client, they are a very smart businessmen. They are very successful. And some of them are very senior government officials who are very knowledgeable in law as well. Of course, they are not practicing lawyer, but they believe that the lawyer are just their assistant, not the advisor. In that situation, they would not depend on you to make decisions. So in the situation where you can't agree with, I mean, you can't agree on the means to achieve the objective, it's up to your decision whether you want to pursue to represent that client, or you can withdraw. Because we cannot we cannot agree on how to do the work, on the strategy, then you can withdraw from representation of that client as well. But again, this I mean, understanding the scope and the objective of the engagement and clearly discuss with the client will maintain the level of trust from client on your service as well. Another important item that is a lawyer must preserve confidentiality. A lawyer shall not reveal information relating to consultation or representation of a client unless the client gives informed consent or as required by law. So under the disclosure of confidential information may be authorized in the following circumstances. I mean, that as a rule, as a professional rule, lawyers are required to keep confidentiality strictly. There are very limited cases where lawyer can disclose confidentiality, such as to prevent certain death or harm. So we need to make a report to the police if we know that there's our client is already bought a gun and going to kill somebody. In that situation, and when you need to report to the police in order to avoid the committing of crime by your client. To prevent client to commit any fraud that you know. That's also the law requires lawyers to disclose information. As sometimes there's a dispute between the lawyer and the client. Then you need to establish a claim or defense on behalf of a lawyer who is in the dispute with the client. In that case, you can also disclose information to the court in order to defend your client. To comply with court order or other law, such as anti-money laundering or counter-terrorism, imposing the disclosures or reporting obligation. These are also a kind of, I mean, there's a certain requirement. Sometimes the lawyer must report. I mean, there's a specific law required that to reveal the confidential information. So if your client involved in money laundering or financial terrorism, and it's considered as a suspicious transaction, then you would be required to report to competent authority as well. So, but the trust and the confidence of client on the lawyer is the lawyer abide by the rule of confidentiality. It's important, like a priest. I mean, the people go to church, they pray and then they tell the priest what wrong they have done, because they trust that the priest will not tell other people that about that wrongdoing. The same as a lawyer, when the client come to see you, and the client can honestly discuss everything with you only if you are able to keep their confidentiality. Other than the rule of confidentiality, the lawyer shall abide by the rule of avoiding conflict of interest. It's also important. A lawyer shall not represent the client if representation involves a concurrent conflict of interest. A conflict of interest exists if the representation of one client will have a direct adverse effect on another client. There's a significant risk that the representation will be materially limited by the lawyer responsibility to another client, a former client or third party, or by the personal interests of the lawyer. A lawyer must not represent anyone in connection with a matter in which the lawyer participated personally or substantially as an arbitrator, conciliator, or mediator in an ADR process. So there's a certain rule of confidentiality that you need to follow as a lawyer. Other important rule is that the lawyer, in dealing with another party, lawyer or judge or witness, a lawyer must not attempt to intimidate or threaten them. You know, oftentimes we see that some clients just want to use their lawyer to threat the other party. But threatening and intimidation is not the job of lawyer. Lawyer is counseling, advising client to do, to do something legally, ethically, in a good manner. So the lawyer must not use any means to intimidate the judge, the witness, or the other party. Lawyer must not lie. Telling lies is unethical for lawyer. Lawyer must not use unjust influence. Unjust influence is influence of like political influence or any administrative authority or public official. Not because I'm a lawyer of for example, I'm a lawyer of a kind of deputy prime minister or prime minister, I can use that influence to take advantage over the other party or to influence the court in order to make decision in my favor. This is called just unjust influence. Yeah. So the lawyer, a professional lawyer would not do that. The lawyer must not make a false allegation. You know that the allegation, the argument you make in the court is completely false. There's no evidence to support what you say, and you know that it's not correct. And the lawyer must not fabricate evidence when submit to court. Falsification of evidence is a criminal offense as well. So these are kind of key kind of attitudes or manner that the lawyer must maintain as a good and professional lawyer. Of course, in court proceeding, the oral or written statement of lawyer submitted to court in good faith for defending his or her client shall not be subject to criminal charge or civil sanction. But if you fabricate evidence or you make false allegation, and then you look very unprofessional. Yeah. The other important thing that you in dealing with client is a lawyer is entitled to charge reasonable fee for his or her professional service subject to agreement with client and the lawyer, taking into account, the scope of work, professional competence, complexity of works, and the outcome achieved for the client. When talking about fee, is very sensitive matter because there's no public standard. If you go to market, to Lucky Market or Eon Mall, if you want to buy a product, you can see the price tags in there. But when the client come to see lawyer, there's no price tags comparing from one lawyer to another lawyer. Of course, within the law firm, there's a standard fee for lawyer working in the same law firm. But if you go comparing from one law firm to another, there's no price tags. So lawyers are entitled to charge fee, which is reasonable for their professional service. And reasonable as a criteria to take into account like scope of service or professional competence. The senior lawyer would charge fee more than a junior lawyer. That is understandable. Complexity of the work. Some cases are very complex. It takes a lot of research, a lot of preparation. Some work are very urgent. They need to prioritize this work, and a lot of resources need to be put into this, the completion of that work. And then they are entitled to charge premium fee. And of course, the client, especially professional business, like corporation, they understand that. But ordinary people, they don't really understand all these kind of things. So when sometimes the lawyer there are some lawyer, they also take advantage over the client on that because they just charge excessive fee. So by charging a reasonable fee can also build a good relationship with the customer, and as well as good understanding. It's also ethical. You're not cheating client because of some work are very easy and very standard work, but you charge excessive fee because of the client lack of understanding of the matter. There are also situations where lawyers should decline or withdraw from representing client if the representation will result in the violation of a rule of professional conduct or other law. Lawyer physical or mental condition materially impair the lawyer ability to represent client or the lawyer's discharge. So, when you are engaged by a client or before you are engaged, as a lawyer, you don't have to accept every client. There are situations where your representation will result in a violation of professional conduct. Then it's fine to just decline. You don't have to accept that client. Some clients, they have like a criminal, their attitude is not a reasonable person. And they expect the lawyers to even to commit crime or to violate the law on their behalf. Then, in that situation, you better reject that client. So to maintain your professionalism. If you involved in committing a crime or violation of professional conduct, your reputation will be damaged. So it's better not to accept. And sometimes, I mean, because you need to understand also your ability to represent clients. There are matters that are too complicated and beyond your capacity. Whether you accept that or not, whether you are like in a good condition to accept to represent client or not. If you it's based on your own conscience, you believe that this matter is not suitable for you, you can recommend client, that potential client, to other lawyers who are more capable. You can tell them that, okay, because you know, in some country, let's say a criminal lawyer, they would not accept to represent client in a security market or banking matter, for example, because some of the matter are very technical, and you can maintain your reputation by also referring that client to appropriate lawyer who have that specific skill. Or otherwise, you can team up with other lawyer who have the skill that you don't have. This is, I mean, that's how you can deal with the complex situation. And sometimes if the client want to terminate you, then you just withdraw. You don't, I mean, generally, the engagement of lawyer by client, the client can terminate lawyer at any time. If the client not satisfied with your service, they can terminate. If the client disagree with your strategies, your approach in dealing with their matter, they can terminate you. And if the client terminate, you don't have to dispute with the client. I mean, some lawyers, they want to dispute with the client, don't allow the client to terminate them. But that's not professional. I mean, a professional lawyer, if the client are not satisfied with your service, then you withdraw. But sometimes, you know, the withdrawal cause adverse effect to client. In that situation, maybe you keep continuing. But sometimes the court does not allow you to stop the representation. For example, like in a criminal case, in a criminal, in a felony, the law requires for the defender to be represented by lawyer in order to continue proceeding. And so if the lawyer are assigned by the bar association or assigned by the court to represent a particular defendant, and in halfway you decide to withdraw, in that case, maybe the judge the judge will say that's not appropriate. And the reason for withdrawal is not appropriate, so you will need to continue. The court can order you to continue in particular case. I mean, this is a case of you decline or you can withdraw from representation in order to maintain your level of professionalism as well. Other than that, the lawyer will have to have a proper law office. We often say, because you know, the lawyer as a professional, you need to have a proper place to work and office. You need to have a proper place to keep your client document files in the confidential area. Normally, lawyer will not. I mean, there's the joke where lawyer just keep the client file in the back of their car. They can go wherever they go, and then they work. Like they have one printer, they have all the client files in the back of their car. That's not recommended because, as we talked from the beginning, a professional lawyer will need to have a proper place and a proper filing area. I mean, there's a situation where a lawyer, they put all the client files in their car, and their car got an accident, and then all the client file was thrown into the water. Cannot find. So as a register, a lawyer licensed by the Bar Association, you are required to have a proper law office place. Lawyer should provide consultation to his or client at a proper place. A lot of clients would like to see you in a coffee shop or in a public area, a restaurant. But you have to determine whether that is a proper place or not. Because when you discuss a client matter, it's supposed to be very confidential. So it's recommended that the lawyer invite client to come to their office and meet and discuss the matter. Don't discuss the client matter in the coffee shop where maybe the other people can just pass by and hear what you say. The lawyer should encourage his or her client to comply with law and avoid advising client to commit any violation of law, crime, or fraud. That's very important because the lawyer know the law and they also know how not to comply with the law. But as a professional rule, lawyers are not allowed to advise their client to commit any violation of law, crime or fraud, etc. especially. So these are kind of elements that could enhance the level of professionalism for lawyers. And all of these matters are regulated, are written either in the law of the bar or the code of conduct for lawyers. When you study lawyers, you pass the bar exam, you got training either by the Bar Association or by the lawyer training centers. There are a bunch of code of ethics that you need to follow. And this is just, I try to pick up some of the key ethical principles for sharing you today. Now we come to the second part. I will go briefly on the soft skill. And as I said, just want to emphasize that soft skill, it is as important as technical skill. Don't underestimate the soft skill. As a law student or the lawyer, most often you might believe that knowing law is the most important part. And I would say knowing law is important to pass your exam, but not really the most important tool to be successful as a lawyer. Why soft skill is very important? It's like a computer. I mean, if you give an example, it's like a computer. A computer that functions well, they need to have hardware and software. Your legal knowledge or technical skill, drafting lawsuit or application, motion statement, would be considered as a hardware. Without proper software, the hardware can function with do very basic work. But if you have good software, you can do a lot of work, designs and everything with software. A good lawyer, same thing. Good lawyer, of course, you need to have technical skill, but in order to be successful as a lawyer in that profession, you need to have soft skill. So what is soft skill? First, we look at the effective communication. The lawyer do a lot of talking, a lot of communications, a lot of writing. So what does it mean? Effective communication for lawyers mean Communicating in a way that is clear, comprehensive, timely, and made through an appropriate medium. It's important to talk to be understood. When you discuss with your client, you advise your client need to be clear so they can understand. You need to be comprehensive so the client can have all the necessary information to make that decision. Need to be timely, as I said from the beginning. From the advice need to come at the right time. Otherwise, they already have a meeting, they already have to make decision. It's too late. Your advice doesn't. Although you have very good advice, but it's too late already. And you communicate with client with appropriate means. How? In writing, or in a telephone call, or in what way? In a WhatsApp chat or Telegram. This is important when you choose the means for communication. The same in court. When you defend your client, you make a statement or you submit a written statement. If your statement are kind of messy and not well organized and not properly structured, your ideas are not clear, then it's also difficult for the judge to understand you. And you know, if you go to court, you defend your client, and what you said the judge cannot understand, then you know what it means. There's a chance that your client will lose the case and lose their benefits. So there are many ways. I mean, the effective communication is so important for a lawyer. In the communication, you need to listen. It is impossible to communicate the right idea to client if we do not listen to them first. The lawyer need to learn what is called maybe the questioning skill. You need to give a chance to client to speak, to communicate with them. Let them share what they think. Let them speak about their problem so you can understand properly. Don't try to interrupt when you are interviewing client. Take time to listen to client and try to understand what they really want and need. Yeah. That's why often, I mean, you need to have full understanding before from the client in order to prepare proper advice and give them advice that are useful, that are clear, and respond to their need. So listen to them carefully. Give them a chance to speak from their heart. When people try to discern the emotional status of client, face-to-face meetings are particularly useful for dispute. Some clients will want empathy, some will want to destroy the target, some will want to reach a compromise. If we don't know their want and need, our advice will be less useful. That's why we need to listen to client. I mean, some clients, they come with in a very distressed mood. There are clients who come to see you and cries. There are clients who are very depressed, especially when you represent client in a criminal case or some family matter, domestic violence, or where they want to divorce, but they are not sure whether they really want to divorce or not. They are in a very depressed situation. So face-to-face meeting and try to understand and the client, explain the client or carefully is very important for lawyer as well. Clear and comprehensive. I said, plan your response before delivering it. think of what you want to say. Think before you say, you know. Avoid lengthy description of law or institution that are of no interest to client. Sometimes the client just want the answer, straight to the point. If you give a phone, like, let's say, okay, I give this answer with the quotation of this article and this article, and what this article said, it's become so complicated for client to understand. Ask the question being asked, answer the question being asked. That's important also. Lawyer need to understand what is the client question. Avoid making statement that give rise to question or preempt question. So don't say anything that will create more question. Your job is to give an answer, not to create more question for the client. Offer practical advice. Sometimes a description of law is not enough. I said when you communicate with clients, try to think of how they can use your advice in a practical manner. What would be a practical solution to this? Of course, I mean, the law say this and that, but how in practice the judge apply the law, the government officer understand and apply their own law. I mean, there's often where the law, let's say in the construction matter, the construction law or the land law say you should do this and you should do that. But when you go to apply to meet the government official who is in charge of making decision, they would not apply the law completely or fully. Then there's a practical way to find solution. So try to think of giving advice which have more practical value, which bring practical solution that would be more useful to the client. Being responsive, as I explained before, prompt, commitment, dedication is important. Time move at a very different pace for lawyers and their client. You know, you want to be slow, but their client want to be fast. And there's somewhere you can meet together. Sometimes there's difficult to meet. An acknowledgement of receipt take less than a minute and make client feel at ease. Their matter being dealt with, at least, you know. There's a lawyer where you send an email today, and then 1 week later they respond to your email saying, sorry that your email go to my junk mail. This is not responsive, you know. As a professional lawyer, usually we apply 24-hour rule. You cannot be in a meeting for 24 hours. Of course, you're busy. You go to court. Maybe you spend like 6 hours in the court proceeding. You cannot reply to the client email. But at least before you go to bed, you can acknowledge their email, their inquiry, and tell them when you can respond. That's called responsive. Not 3 days later and say sorry. There's a situation where, okay, you are a lawyer, you got 100 emails per day. I overlooked your email, but that word not convenient and not comfortable, you know, for the client. You need to maintain a high level of responsiveness. I mean, you don't have to provide a substantive response at the first time. At least you acknowledge it and then tell them when you can respond substantively. This also makes you look more professional. Sometimes using email, you know, people are copying one email, keep them copy and all respond. It's enable people to know what's going on and say following up. That's just kind of communication, because if normally in a large law firm, like in my law firm, we work as team. We have senior lawyer, we have advisor, we have assistant who work on the matter. Sometimes we have Cambodian lawyer, we have foreign advisor working together. So try to keep everybody involved copy, so we are on the same page. Try to cover everything in one email. Multiple follow-up email indicate a lack of clarity in the mind of writer, which is not what the client look for in a lawyer. Yeah. So, I mean, sometimes you send so many emails, just one, very often it's become very destructive. So try to put your response in one email if possible. Try to keep all correspondence in one chain. This makes researchers much easier. Your signature need to appear once in an email. You don't have to every time attach your email signature. I mean in the reply email. Using WhatsApp and Telegram chat. Sometimes, you know, now it's very convenient that people can use chat app. But for the professional work, sometimes they also have disadvantage of using that tool. The using of short message in the chat app, sometimes it lack of security. Communication between lawyer and client typically contain information of value to like criminal. Security is paramount. Some but not all chat app offer end-to-end encryption. Some chat app store message in the cloud. So you need to be aware of the using chat app, which does not protect security for you. Using chat app sometimes is unwieldy, difficult to read, difficult to compose message, how to store attachment, difficult to search, difficult to forward message. So some chat app that you use have also inconvenience and disadvantage in using email, proper email attachment still very I mean, the email, you can have a security protection server in your servers, and you can properly files, you can properly search back file, because if you work on a matter like it takes several months, and if you use some chat, maybe you cannot store it, you can delete it and you forget it. But if in email, you can get it back, retrieve it for a very long time. Lack of possession. Information stored on individual phone will be taken with them when they leave the firm. You change the phone or you leave the firm, some of them may lost. There are laws that require a copy of document to be retained by a company, like tax law. You need to keep document for a number of years. Those documents may be retained if they have been sent by phone to someone who have left the firm. So you lost because the lawyer are not there, and the documents are not stored at the firm database. Even where law does not require retention of document, it's prudent to do so. The client may call, some year later to discuss the old matter, and you cannot find the file. The government authority may seek copy of document. Such document may be requested pursuant to discovery proceeding or other legal arbitral proceeding. So maybe when you draft contract, there's no dispute. It's okay, chat with WhatsApp or Telegram. But maybe 2-3 years later, the enforcement of contract goes sour, and then there's a dispute. And you need to check the background of the discussion of the drafting. You can't find it because it's all in your WhatsApp on your iPhone, and you already lost it. So they just chat up some very informal and pragmatic message. We tend to use casual language and contraction. For example, like I sent it to you before. You know, sometimes we use a very friendly manner. It's not a formal communication between lawyer and client. This is not appropriate for lawyer communicating with their client, and it can lead to a lack of clarity and misunderstanding as well. The casual nature of communication made through that chats up side of the screen and can lead us to write brief and incomplete message. I think that are also inconvenient because sometimes you know the chats up easy for you to send, and a lot of clients from overseas now because I mean my client often like contact me through WhatsApp or Telegram. For the Chinese client, they use like WeChat contacts, but that's for a small setting up a meeting or a short question answer. Maybe it's okay, but when you really want to come to a serious matter, serious advice, I mean, it's advisable to use email. It's more appropriate. One more thing is lawyers should always treat client and colleague with respect as a good manner. Client, colleague, friend, or maybe, or if you go to court, the court officer and the judge, you, of course, I mean, you have to show their respect. When our client are angry or frustrated, it's over something they are completely wrong about it. The temptation is to fire back will be there, that resist. Take a deep breath before responding and renew your response before you send it. I mean, we are also sometimes, as a lawyer, sometimes we are also very frustrated. And it's a kind of your client. We have a client who is very annoying. They text us, they call us in the evening, and they ask very stupid questions. Then you can feel that, but you have to hold it. You don't show your emotional, I mean, stage. You don't fight back with the client. You never win when you fight with the client in emotionally. So as a lawyer, should calm down and then think of your response. Sometimes, of course, you don't have to respond right away. Maybe take 1 hour or 2 hours later, when you feel that maybe okay, your client calm down already, and then you also in a good mood, then you reply back. But yeah, don't throw the ball back to the client. I mean, we need to be friendly with our client and make sure they feel that we are on their side. We need to be friendly with client and make sure that we are on their side. So the client trusts you if they feel that you are working for their advantage. You are representing their interest, demanding for their interest. There's a situation where the client believes that you are serving the interest of the opposing party, and you are not working serious enough to defend their interest. You are not so friendly, you are not responsive to them. But I mean, friendly with client here, there's also limitation. You cannot be just too casual with the client. I said from beginning. There's also restriction in the code of ethics. There are lawyer, I mean, straightly speaking, the lawyer should not have emotional relationship with the client. You can be friend, but there's a certain distance that you need to keep. Not about comment regarding effective communication. Communication should be always be polite and helpful. That's the objective. The people will not judge you because you are, as a professional lawyer, if you are impolite, you are rude, and you are like, another thing is search for knowledge. It's not enough to merely know the law and keep ourselves updated on new development. In addition, we need to continually learn about ways in which we can provide better service to our client, understand our client and sector, industry they work in, increase efficiency and staff satisfaction in our office, develop as leader, develop business, contribute to society. So, as I said from beginning, that you need to learn a lot of things, learn more, learn the business. You know, sometimes learning business management is also very helpful for lawyers. You understand how the market works. You understand the competition in the market. You understand, and then you can properly manage a law firm. When you run a law firm which have a certain number of staff, lawyers working together with you, it's not like a solo practitioner. You do everything by yourself. You need to understand the management skill. You need to understand human resource issues. You need to understand to expand your business, competing with other competitors in the market, etc. These are all you need to learn more. So what we call it, sometimes we call it the quest for quality, improve quality of whatever thing you do. So keep learning and understand and have more knowledge as possible. And sometimes, sometimes my advice, there's a day when you need to forget about law. If you want to read something, like, the lawyers must read criminal code, civil code, code of civil procedure, or criminal procedures, or any textbook that explain all this kind of provision. But there's time where you just need to leave those laws behind and then start reading other things, reading leadership, reading marketing, reading other book. When you read the other book, the other sector can sometimes also give you different perspective on the legal industry, on how the lawyer work, on how the law firm operate, etc. So, mostly what I can say from my personal experience, I'm operating HBS as like the same as a other corporation, other business. We face the same issue as the other business entity. One more thing is about empathy. I talked briefly before about empathy, but showing empathy is not the same as showing sympathy, pity. You're not pity or sympathy about your client, but empathy is showing to client mean that we put ourselves in their shoe and try to understand the feeling and need. Understand the feeling and the need of the client, understanding. Clients are all different and have different needs. For example, client may require a lot more hand holding in criminal or contentious matter. Some clients like to communicate face-to-face by telephone, while others prefer email. Some clients wish to defend the principle, while others just want the result. Some clients are from highly bureaucratic organizations and have to report to the other, a situation that causes them stress, while others are the ultimate decision maker. So understand their situation where they are in can also help them a lot. The above are merely examples. There's numerous other aspects in which a client need may differ from those of the other client. Even among the client, they can have different need. The best way to understand the client need is to get to know them. There's nothing wrong with meeting for coffee or drink. Okay, meeting and discussing not only the legal matter, but discussing about the business, about the other thing, about their life, about get to know their business. Every meeting should start with a lawyer getting to know the business, how it operates, and any issue that might impact on the way legal services are delivered. So having empathy means understanding, not having sympathy. Reliability is important. Reliability is key to delivering good legal service, and mean that we do what we say. Okay? Some lawyers believe that it's acceptable to send client a work product after an agreed deadline with nothing more than apology for lateness. As I said from beginning, you're not reliable if you always say, I'm late, I'm gonna apologize. But so you need to keep your word, keep your promise as much as possible. Strong work ethic. Having strong work ethic is important for our client and our colleague. When we work on project with other lawyers, they depend on us in the same way as clients do. A lawyer will need to get the job done. If that means staying late in office or working from home, that is what we must do. Wedding or family gathering are not reason to be redirected in the duty. Be accessible to your colleague and your client. Give clear instruction to junior lawyer in your team. Kick-off meeting as a must for big project. So this kind of work in ethic in the firm. There's a situation where, for example, sometimes like traffic jam is not an excuse. Okay. You go to attend the court proceeding late and you explain to the judge, I apologize because of traffic jam. If you say that in front of your client, the client will say you don't take their case seriously. So this is a very ethic. You need to, as a lawyer, you go to court between 15 to 30 minutes before the proceedings start. In my experience with foreign clients, a number of professional business people, they go to court like 30 minutes before. Everything get organized. If you forget any document, you have enough time to call back to office and deliver to you on time. But if you are showing you don't take the time, you don't take the the punctuality seriously, that's not a good work ethics. It's not you are not reliable as well. So I think I try to cover everything prepared in the slides, and I talk much longer than expected, but of course welcome to receive your questions. Any question that you want to ask me more on this presentation or any other topic related to the professionalism of lawyer.
I think thank you, Mortai, for a very insightful presentation and very intriguing. I think I have received, I think lots of questions from our participants, ranging from professional conduct to soft skill as well. But I think I'll go into detail later. But for overall, I think this presentation, it highlights two prongs, which is the professional conduct and soft skills. And to summarize, I think we all have understood the essence of ethics for lawyers. Similar to doctor, I could say that lawyers have their own code of conduct as well. So I think this is something that really sparks my interest. And at the same time, while we may see that soft skills may be a minor thing, but as Mr. Taiseng has highlighted, it gives off you a charismatic aura, and it shows how responsibility you are. And I think minor things such as just prompt response to clients, it may affect how the clients view you as a lawyer as well. So lastly, I think which is what Mr. Taiseng has highlighted is you may need to leave the law behind and read other things, because this allows you to understand the client's business better, and this is something that allows you to outshine other lawyers who do not really uphold those values. So I think right now it has come to the Q&A session, and I think I may start with the first question. I think one of our participants has asked that as a lawyer, do we need to know to really get into close contact with the client, or just we only need to know just the basic information about the case and about their address or their similarly or their jobs, and what do you suggest as a an approach to client? What is the relationship that we should have in that regard? I think that's the first question.
Okay, yeah, I think that I have a cover a little bit there on being friendly with client. The intimidation between the intimate relationship with client is, I mean, as a professional, you need to have a certain distance, speaking. Of course, you need to have empathy, try to understand the client, put yourself into their shoes, but don't be too close to be too casual. In some countries, I mean, they have a limitation where the code of ethics of lawyer, I mean, of course, there's a woman attending here, that lawyers are not allowed to have sex with clients. It restricted, officially written in the code of ethics. So by being friends, or by being too close friends with the lawyer, I mean, sometimes you compromise your professional principle, the ethical principle. But of course, I mean, the lawyer represents friends, close friends, the relation that you have before the engagement. You don't have to, I mean, to get away from what the friendship you have before. For example, you are our classmate now, and one day one of you become a lawyer, and you don't have to behave differently when dealing in a private matter. But when it comes to the legal matter, the representation or the counseling matter, you need to have a certain distance. Okay. So try to separate between private relationship and a professional relationship. This is important.
Okay. Thank you for your answers. The second question, I think, is very interesting as well. I think this is mostly, I think, based on your experience. The audience, I think the participant has asked that on which basis or qualities does an associate climb the ladder in the law firm? Because, for example, in the law firm, you have associate, you have senior associate. So what are, as a managing partner, what do you, normally value, to allow the associate to climb the ladder in the law firm?
Okay. I think there's no one right answer for that, because each law firm will assess. They have their different way of management, and normally the associate in my knowledge, some of the associate you start a fresh graduate or a new lawyer. For the first 2 to 3 year practice, you might start as an associate. and then you move up to senior associates, and before you become partners. So partner of the firm, sometimes it takes 5 to 10 years before you can be qualified as a partner. But that is not the only conditions. The seniority is one of the conditions, but as a lawyer, the core is the competence is also taking into considerations. Some lawyer, they start associates, but they are very good. They have very good skill and competence that the law firm need and can be promoted as well. Some of them, they start practice new, but they have a kind of master degree or PhD degree. Their education are also taking into account in the determining their competence in the practice. So that I would say there's a few factors that need to consider. One is the seniority. Second is the educations, qualifications, and the other is the competence. Sometimes the law firm, we need a kind of special skill. So a special skill, sometimes we do what we call a lateral hires. When we hire the other senior lawyer from who have left the other law firm to join, and then they can join as they start as a partner already because they are very senior when they work in the other law firm. They don't have to start from beginning. Okay.
Yes, thank you for this, for your answers. I think the third question, I think there are a few people that have asked, I think there's quite similar questions regarding the confidentiality, because as I think as you have mentioned, is the lawyers, they must preserve the client's confidential information. But there are cases, for example, like what if the confidential information is required to be disclosed, but then the client disapproves, or what if the clients try to lie us or conceals the truth or hide the truth to begin with. So for instance, I think he has raised an example, like for example, A is the killer and only his father witnesses the murder, and however, to protect his son, the father testifies that he's the killer instead. So in that case, what should the lawyer do, or should the lawyer follow the client's intention by allowing the court of law to prosecute the father, or should he proceed against the client's will by just revealing the perpetrator, okay, saying that the actual killer is actually the son. So but then he also kind of adds a little more information that, but if the lawyer just disclose the information, wouldn't that constitute a breach of client attorney privilege instead? So how do we reconcile these in this kind of situation?
Okay, I think let's go back to the principle. So in principle, the consultation representations of client, any information that you have been provided by the client are supposed to be confidential. But as I said, there's a situation where the lawyer is not allowed to tell lie. If you know that one of the fact is incorrect, and the client insists that you make that statement, so you have to decide whether you make that statement or not, because you know that it's incorrect. So in the situation, if your client is the son or the father, and if your client is a father and you know that he's the one who killed the other, not the son, then the fact is incorrect, and you are not allowed to telling lie. So of course you can advise them and what is their legal rights and what they need to do, but telling the judge, lying the judge with the facts is incorrect. So in that situation, it's your professional conscience to determine whether you will continue or not. I'm not going to tell to make a false statement anymore.
Thank you for the interesting answer. I think there's another question regarding regarding the legal fees between the client and lawyers, because I think there are times that we might, the lawyer and the client might be having some legal disputes regarding the fees. For example, they have agreed on this fee, but then the client did not pay, for example. So, in that kind of situation, I think it's she has asked about the which court is competent in that regard, and I think probably to add up, how should we do this? Should we try to maintain the relationship, or should we go to the court directly in that regard? Yes.
Yeah, and I mean that's oftentimes we do have faced that situation in as I said, as a professional conduct, when you are engaged by the client, you need to be specific, clear what is the scope of your engagement. And the other thing is, what is the fee you charge? How the fee will be paid? That is you need to be clear on that. If you are not clear and then you just start, then there will be often there's a misunderstanding. The client will expect you to charge a low fees, where you expect to charge high fees because of the complexity of the work, etc. So in the event of dispute, if you want to claim from the client, then follow your contract. At the engagement, and when we do the engagement, normally there's a term and condition for the engagement. Engaging a lawyer is also a contractual relationship. So if there are any dispute resolution clause stated in the term and condition of the engagement, then you follow that. Otherwise, in the absence of any negotiation or arbitration proceeding, then you can just go to court, competent court. That is straightforward. However, from the client perspective, if they have a kind of dispute with the lawyer, they can file a complaint to the Bar Association. That's from the client perspective. So client does not agree with the fee charge, and believe that it's not, you are charging for something that have not been engaged for. And I mean, your description of work is not correct. The work that you spend only 2 hours, you charge 5 hours. So this is kind of disagreement. Then they can complain to the Bar Association. The Bar Association will examine that. They have a team there to review that as well, to resolve conflict between the lawyer and the client.
And thank you for the this intriguing answer as well. And I think there are a few questions left. I think I will start with the point regarding, I think you've mentioned that lawyers, must keep themselves updated, with news and etc. So I think one of the audience, has tries to, is asking whether, how do we remain updated, for example, with the legal news and especially the Supreme Court's judgment, given that, we're not in Cambodia, we do not have published judgments in that regard. So how do we keep up with the legal updates that have been published, consecutively? For example, within just regularly, there have been laws regarding the COVID-19, etc. So how do we try to update with these updates, especially when there's no published judgments, for example, of the Supreme Court?
Yeah, I agree that there's limitations, but I mean it's a matter of so in searching for information, there are many ways now. There's a lot of information available online on Facebook, Google. Okay, different ministry, different institutions, they publish their new decision, new regulations, even law very quickly on Facebook now. On their website, you can search. Just keep keep following them. Of course, I mean, Cambodian court does not publish their decision. That is one of the difficulties and challenge for lawyer. All a lawyer not practicing law here, you do not have access to court precedent, the court decisions. So in that situation, I think the best way we can do is ask your colleague, ask your other lawyers, ask whoever may be represent in the Supreme Court. They have case to the Supreme Court. So if there anything new, that any decision that overturn the previous practice, you don't have to follow every decision, because I mean the court make 100 decisions every year, but only some of them have a significant impact on the practice that is necessary for you to try to know. But in this the situation, we need to either you have a good relationship with the judge and keep asking them any new decision come out, or ask your lawyer, your fellow lawyer, if they have anything to share. I think this kind of job, maybe the bar associations and the Ministry of Justice and also the court will need to work more on how to widely circulate their decisions. In other countries, they have a law database, they have a judgment database where you can subscribe. Like if you can like go to Lexis or Westlaw in the US, then you can have all the court decisions that published there. But in Cambodia, we don't have that software that we can search.
Yeah, thank you so much for the answers. I think this question comes from a student. I think she has asked about how should she shape her career, because right now she's interested in commercial law, and so what what do you suggest in terms of for example academic subjects and extracurricular activities that she should take during law school, and as well as any institutions that you would recommend to sharpen their her commercial law skills. So what do you recommend in that regard?
Yeah, okay. I think at the undergraduate levels, when I was a student, there's there are kind of different divisions between private law and the public law. So those who are focusing on private laws, they're more going to like learning commercial laws, contract law, or the other other specific law like bankings and securities. But in terms of orientations, if you are interested in the private law area, I think try to read as much as possible contract law, company laws, and follow up like Ministry of Commerce and Ministry of Economy and Finance, and a number of regulators under Ministry of Economy and Finance, bank. I mean, when we talk about commercial law, they are also very broad. There's many other subjects like intellectual properties and many other private area. So in addition to the substantive laws that I just mentioned, I think tries to engage or involve in practice in the private area as much as possible. Maybe in my suggestion to the law student, if you are like, if there are any opportunity for internship, maybe if you really want to go to a private practice, tries to apply for internship at a law firm. Especially in a private law firm, they have a lot of commercial practice where, I mean, you can start getting to understand the legal practice and the commercial transactions as much as possible. So involving and get also outside training. I mean, like for example, like the webinar that we are conducting now, and the other school that they provide some specific training on the special subjects in private law. That's also important outside. Not only just focus on reading your textbook to pass the exam. Go outside. I mean, my personal advice: try to connect the outside world as soon as possible while you are a student. Don't wait. I start working since I was in year 2 at the university. Although I start as a translator, but by doing translation work, I can read contracts. I can get a contract and translate it, and I get paid for the translation. I understand how the contract is written when I was in year 2 at the university. So either get an internship at a private institution or at the Ministry of Commerce or Ministry of Economy and Finance or National Bank of Cambodia, etc., and try to get extra work, extra job, all whether it's paid or unpaid. But you can understand how the outside world they practice.
Thank you for this experience sharing for our students. And I think there are only, I will have 2 questions left. I think that would be the end of our webinar. So the first question that I have here is, I think it's more on like in a scenario in which the client comes to the lawyer on issues that a lawyer have limited knowledge on. So what does a lawyer, practically do? So should we schedule a future appointment to have some time to do legal research, or should we, try to, answer it so that, we can appear appear confident toward the client? So, what should we do in that kind of situation that we have limited knowledge on the subject?
Okay. Yeah. I think that, I mean, often we face that situation. As I said in my presentation, I mean, lawyer is a human being, and it doesn't matter how much you learn, how much you try to research, you're not expected to know everything. But you know how to find the answer if there's any questions. When you meet a client, sometimes there's the face-to-face consultations where the client expect a spontaneous answer to their questions at the meeting. Then if you don't know, you better say that you don't know and you need to do further research. If you don't know, don't try to tell anything that make you look stupid. That's good. The client understand that sometimes the lawyer don't know, but you tell them how you're gonna tell the answer. Maybe you will need to discuss on that matter with my partners. Because, for example, like I'm specialized in banking. For example, if client asks me on any question on banking practice, I would answer them straight away. But if client come to ask me on IP matter, I will say, okay, I will check with my IP partner in the firm. My firm is, you are junior lawyer, you say, okay, I will check with my managing partners or my head of practice group, so they can understand, they have more experience on that. And you tell them back. This is a kind of solution. There's a matter where even your partner cannot tell you what to respond. Then you need to contact with ministry. For example, this question cannot be answered because I need to call the legal department at Ministry of Commerce to explain me, to confirm what would they mean by this article. So you don't look stupid if you just tell them that this you need further research. You need to confirm this matter with ministry or with the competent authority to give the specific answer. Of course, you can give them that the best, to the best knowledge that you have. This may be like this and like that, but you need to confirm and verify with other people in order to give a concrete answer. It's a matter of communications that you need to handle that situation.
Thank you for your suggestion, and I think this is the last question from our audience. He has asked about about more of a career of the lawyer, because normally lawyer, when we graduated, we don't normally earn a lot. I think that also applies to other jobs as well, for law students. So his question is, how can a lawyer find kind of improve and get experience and legal knowledge, and at the same time trying to earn some money for their personal life as well. And so how should we balance this? Should we try to do jobs that give you more money, or should you try to go to, for example, more like a big law firm? It's hard to climb up the ladder, but then you really learn a lot from the law firm. So what do you recommend in that kind of situation?
Yeah, it's a very important question. I think in life you need to balance, and you need to have your clear objective. What do you want? You want the knowledge, or you want the money? And practicing law does not always guarantee a lot of money. And there are some successful lawyers who are super rich. Also, there's also the failed lawyer who are not very rich. They also face the same financial problem as you as a student. My suggestion is to balance. Why? I mean, you should prioritize your personal life objective. If at your young age, earning more knowledge and skill is the first priority, improve your skill. When you have skills, you build reputations, and then sooner or later, I mean, you will make money from that skill, that knowledge. You cannot, I mean, logically, you cannot be paid premium fees or charge, I mean, a very high fee, the same as like 10 or 15 year experienced lawyer who already built a reputation, who already have a list of their good client in hands. So you need to start step by step in order to be able to succeed in professional life. But as I said, lawyer, I mean, as a public citizens, we are also a human being. Making money is not the only objective. And a successful lawyer is not only determined by what car they drive, which house they live. There's a very reputable lawyers who are just doing a public interest work. There's lawyer who represent the poor criminal or poor defendants and the poor people in the rural area. They don't really make money from that. And they're still very successful in the sense that they manage to push for the reform of the judiciary. They protect the public goods, the public interest, for the good cause of the society. That's those lawyers as well. So if your aim is in the private sector, private practice and make money, then go to work for a big law firm. But if your aim is to contribute to the society by other means, you become a good lawyer with a reputation of defending the poor people. You can be also succeed, and you can also satisfy with their career. So at the end of the day, it's a career satisfaction, There's a lawyer, I have a lot of friends who are very successful lawyer in terms of making money. But after you have a certain level, a certain amount of money, the money would not be a motivator anymore to drive your career, to make you satisfied with this career. Then you look for other things. But then, I mean, there's many ways the lawyer can be successful. My advice to a young student is don't just aim for money. Aim for something good for society that are could be more valuable than making money. Of course, you need money to live. You need the money to pay for your subsistence. You need your family will need money to survive. But of course, after you have a certain amount, then try to do something more important than making money. Okay.
Thank you for your advices to our junior legal practitioners as well as students as well. And I think this has come to an end of our webinar today. And thank you for the presentation, and especially how you're able to be flexible with our webinar today, given that Mr. Patrick isn't able to attend. Thank you very much for your dedication, and I think everyone really appreciates this. And thank you for the questions from our participant as well. And I think I apologize that I may not ask all the questions, because I think there are too many questions that have been asked, but we have a limited amount of time. So I think, as I've mentioned, it has come to an end of this webinar, and I would like to have a photo session if possible. I think if everyone could turn on their camera a bit, just to have a photo session, and if possible, may you turn off the sharing screen, because I think we could not have the full screen. Yes, thank you. Okay, I think I would count from 3. Okay, if everyone could turn on their camera. Yes.
Okay.
Okay, so it will be a screenshot. So yes, so we can wait for a few seconds. Yes. Okay. So I will take a screenshot on the count of 3. 3, 2, 1. Smile. Okay. Thank you, everyone. Thank you, everyone, for your participation in this webinar, and I think it's a big success this time with our participants today. And thank you for your questions, and take care with this COVID-19 pandemic. And I wish you all the best of luck for your career as well as your academic life if any of us are still students. So thank you very much, and have a nice weekend. Thank you.
Okay. Yeah. Thank you, and stay safe and have a good day. Thank you, everybody.